Hello, everyone. Welcome to LL.B Radio, I Rest My Case podcast, a podcast that will simplify complicated and interesting legal issues for all. Today, you're with me again. Hi, your host for this podcast. And you may be wondering why I'm not speaking Thai. That is because today's episode is indeed a very, very special one. The first special thing is that it will be conducted in English, as you all can hear. Secondly, we have another very amazing host. And thirdly, we also have a very, very, very special guest. So right now, let me introduce you to our another host of today. Welcome, Mix.
Hi guys, my name is Mix. I'm the second year student, and I'll be your co-host for today's episode of I Rest My Case podcast. Well, to say amazing would be a little bit of an overstretch, but I'm okay with that.
Yes, you are. No exaggeration at all. Okay, Mix. Well, so thank you very much for coming. I'm very happy that you're here. How's life lately?
Well, thanks for asking, Pai, because it is amazing. It is so nice to see everybody back at the university again after a whole year.
Yes, it's been a long time, a very long time. Yeah. But now we can come back to see your friends, see each other, see real people. What an amazing way to start the semester, right?
Yes. But do you know what is better way to start a semester?
What? There are better ways to start a semester?
Yes, there is a better way to start a semester by listening to our new episode of I Rest My Case podcast.
Oh, I see. So now I think we have to get this started so everyone can start their semester so awesomely. So yeah, because today we have a very, very interesting thing to discuss, right? What are we going to talk about today?
Well, we are going to discuss something that may not be the most upbringing or joyful topic, but interesting nonetheless. It is about a 100-year-old man being accused of a Nazi and is currently being prosecuted at Germany.
So a 100-year-old man is being prosecuted?
Yes, a century-old, actually.
A century-old man? Wow, what crime would a century-old man do?
Well, he was accused of being a part of a Nazi elite guard, something that you would pop out of a Hollywood movie or something like that.
Wait, so Nazi elite guard, it happened like so many years ago. It was during the World War II, right?
Yes, he was probably back in his 20s or 30s by then, if he's 100 years old.
So you're saying that a 100-year-old man, is being prosecuted for a crime he did when he was 20, 30 years old?
Yes, exactly.
Okay, now this is very weird. So let me explain our audience the details of this case. This is about bringing an old Nazi guard to the trial in Germany. Well, you may seem surprised about this, but actually this cases like this is not new. But this current case we're talking about is the case of Mr. Joseph S.
Mr. Joseph S. Yes, when I read this case, I was wondering, is S his actual last name?
Well, it isn't. His last name is definitely not S, but he is referred to as Joseph S due to the right to privacy in Germany. That is the reason why his name is not fully revealed to the public. However, though we do not know his full name, we do know that he was a Nazi Schutzstaffel guard at the Sachsenhausen concentration camp during 1942 to 1945, about the end of World War II. And we also know that he was tried at Neuruppin court. And Mix, do you know what are his accusations?
Yes, I do. Hear you out. These are his accusations. He was involved in, hear this out, 3,518 murders of the prisoners at the prisoner of war camp, being accused of knowingly and willingly assisted the murders with charges like accessory to murder of executing Soviet prisoners of war by a firing squad, and accessory to murder using the Zyklon B. If you don't know what the Zyklon B is, it is a cyanide-based pesticide, which is already deadly, but it is being used as a poisonous gas by the Nazis to execute prisoners using their infamous gas chambers. The gas chambers is what the Nazis use to kill Jewish prisoners who are not selected in their work group or is unable to work no longer.
Whoa, so this man killed like 3,000 people. That is a lot.
Yes, that is more than I'll ever meet.
Yeah, so this makes me confused even more. Like, he did such a big crime in a very gruesome way, but why was he not prosecuted back then, but was just brought up to court now, right?
Yes, and what of the statute of limitation? Like, shouldn't this crime be already expired to prosecute it?
Yes, I think this will be answered in our episode today.
Yes, but with only the two of us, this would get nowhere.
Yes, we are very lucky today, and because our special guest is our assistant professor, Dr.Lasse Schuldt. He was born and raised in Germany and received legal education from Humboldt University, Berlin. And before becoming an assistant professor at University, he worked as criminal defense lawyer. So everyone, please welcome Ajahn Lasse.
Hello, everyone. Thanks for the invitation.
Welcome, Ajahn Lasse. It is so nice to having you here, because without you, we would not understand any of these topics. Well, but you need to know something. You are actually our first guest in I Rest My Case podcast. How do you feel?
Oh, I'm very honored. I'm very honored. Thanks a lot for the invitation.
No, you should be honored.
Well, I hope I can live up to your expectations.
Well, Ajahn Lasse, how is life?
Well, life is getting better again, I think, right? We are seeing the end of the COVID-19 pandemic, perhaps this year. Let's be optimistic. So we are now coming slowly back to class. I could hear that you are also celebrating that a little, that you are able to do the hybrid classes now. So, well, I think this year might be a year where we can be a bit more optimistic than in the last.
Yes, let's hope everybody is back here soon. Students and Ajahns alike. Well, let's talk about a background that Pai just said. So you studied and worked in Germany for almost your entire life until you moved to Thailand, right?
That's correct. Yeah, I received my legal education in Germany, and then I practiced as a lawyer also in Germany. That's correct. Yeah.
Well, that is great, because World War II is a huge impact to history, and we Thais doesn't have enough education into World War II. How was it different in Germany, actually?
Well, actually, the Second World War, and particularly the Holocaust, are a very key element of German education. So you cannot go through, I think, even a single year in school where this era will not be a topic of education. So it is really regularly studied, and there is then also quite some emphasis on the, you may say, on what happened after the Second World War, what kind of measures were taken to somehow address these issues, and how have previous generations addressed what has happened during the Second World War. How is the issue about guilt? How has that been addressed in German society? So it is not only the events of the Second World War and the Holocaust itself that we study at school, but we also look at what have generations before us, but after the Second World War, what have they done to somehow come to terms with that history?
Wow, look like we couldn't pick any better person here, right, Bai?
Yes, and I think like every German has also a profound knowledge about World War II and Nazi, right?
Well, I think it depends. Yeah, I think it depends. There are obviously some that also are privately interested in the topic because of their family background. So they may really then go into much depth and look at what have my family members, which role did they play? Obviously, also the Jewish families in Germany, they have a particularly high interest, because many of them, or maybe even all of the Jewish families in Germany, have some victims in their families. So it depends always on your private background as well. But generally, I would say, at least via the school education, everyone has a basic knowledge that is, I think, quite sufficient. Yeah.
Yeah, I see. Because us Thais have almost no knowledge about this, right?
Yeah, it's like the complete opposite of German here. Germany there.
Yeah, but that makes sense anyway. We know our history, I believe. Okay, so yeah, without further ado, I think we should come back to our case here. So the case of Mr. Joseph S. Ajahn Lasse, as mentioned before, Joseph S. committed the crime 77 years ago, right? But he was just brought up to court now. So I want to know what are your thoughts on this? Why was Joseph never accused or being charged immediately after he committed the crime?
Well, I think that's a very important question. So many have not been charged right after the Second World War. So Joseph S. is just one among many who has not been brought to justice earlier. By the way, it is not that he committed these 3,418 murders himself, but it is really assistance to these murders. But this kind of case, that there were guards or watchmen from concentration camps that have not been brought to justice for any particular actions they conducted during the Second World War, that has unfortunately been quite a pattern after the Second World War. Now you may ask why? Why have so many gone free? So, I mean, first of all, if we take a look at the immediate aftermath after the Second World War, then you might see Germany was occupied by 4 powers, which were the United States, the United Kingdom, France, and the Soviet Union. Now, the Soviet Union actually conducted quite a number of trials. So about 50,000 people have been found guilty by trials conducted in the Soviet Union occupation zone. In the Western zones, the French, UK, and American zones, the numbers have been significantly lower. And now you might ask, why was that the case in that very initial time? Well, actually, you might see that the prosecution of perpetrators has been influenced also by political considerations. So there have then been, right after the Second World War, there has been the famous Nuremberg trial, and there have been other follow-up trials conducted by the American, French, and also British occupation zones. But after a while, this slowed down quite significantly. And then maybe some low-level perpetrators were still held liable, but other high-level perpetrators have actually then largely been set free. So why was that the case? Well, you need to see the political circumstances at the time, which were basically the dawn of the Cold War. So the United States wanted Western Germany as an ally. And that was the reason why they didn't want to be too tough on Germany anymore. And they also were aware that if we want to build a strong German state, well, we need civil servants, and we cannot put everyone into prison who was formerly working for the Nazis. So we just need these people also. So there were very pragmatic considerations and also political considerations that after a certain while, the trials just were somehow slowing down very significantly. And that was the reason mainly why then for many decades also, not much happened.
Oh, yeah, this is actually very surprising. I thought it was like domestic matter in Germany, but it's actually like political matter that involves other countries, right?
Well, at least for the first 4 years of occupation, that was the case. Afterwards, after then the Western and the Eastern German states were founded in 1949, well, after that time, their own decision to perhaps not go too deep into these issues led then basically to the continuation of the lacking of the prosecution. Yeah, so then in the 1950s, a few trials were then done in Germany, in Western Germany, but these were very few. So only a few hundred people were then prosecuted. And then during, or you can say towards the late 1950s, early 1960s, it basically almost ended. And then only a few cases were conducted. And that indeed was the decision of the domestic German prosecutors, who did not feel that there was any need to go any deeper.
Oh, so they just basically did not feel any need. But why all of a sudden they feel the need to prosecute them now?
That's a good question. Yeah. So now you may really ask yourself, well, you have waited for more than 70 years, and it is very difficult to get evidence nowadays with that long distance. Why would you start it now? Well, you may say one reason why this is why that for the last 10 years, we may say there have not been frequently cases coming up, was a change of jurisprudence by the highest German court. And that change of jurisprudence basically makes it now much easier for prosecutors to bring these cases. Because as you've mentioned in your introduction to this case, this is actually a case of assistance to murder. Joseph S. did not himself personally kill anyone, but he was a guard in a concentration camp, and he was working, for example, in different positions, taking care of the security of that camp. That means making sure that no one leaves, and making sure that some order is kept in that camp without, however, physically killing anyone personally. And in 2011, the German Federal Court of Justice decided in a similar case that this kind of just being a guard is enough to hold someone liable for assistance to murder in that may be up to 300,000 cases. So there was then later a case decided against the defendant who was named, or whose name was Oskar Gröning, and he was found liable, also then based, or that was then affirmed by the Supreme or by the Federal Court of Justice in Germany, and he was found liable for assistance to murder to 300 or in 300,000 cases. And since this jurisprudence then came up, so this was a major change in jurisprudence, because until the 2011 decision, which was the Jon Demjanjuk case, which was actually a case decided by a court in Munich, until that point, it was always understood that if you want to find someone liable for assistance to murder, it needs to be a rather concrete offense to which someone has assisted, so that you can really say, well, that person assisted to that particular action at that particular time committed by that particular person. And then you have assistance to that. But since that decision in 2011, and then a later decision by the Supreme Court or by the Federal Court of Justice, that is not necessary to be proved anymore. This connection between the Assistance Act and the main act is now very loose, and just anything that happened in such a camp can now be attributed or cannot be connected to assistance. And I personally also think that that is a bit problematic from the perspective of criminal law doctrine, but nonetheless, that has now been the jurisprudence. And since then, the prosecutors thought, well, now it is much easier to bring these cases, and that is the reason why for the last 10 years, we see still frequently cases, although we also need to say the cases will in the end come to an end because the perpetrators will die. As you mentioned, in this case, by the way, Joseph S. is now already 101 years old. And as we know, these perpetrators, or these alleged perpetrators, but many of them, I think there is good evidence that they have worked in these camps. They will at some point just die, and then there will be no cases anymore.
Oh yeah, now this is much clearer, I understand. So because it is easier to sue, it is easier to convict him. That is why he was prosecuted just now. Okay, but yeah, from my knowledge, like in Thai law, I don't think this is possible, right? Because we have this thing called the statute of limitation, that when a crime was committed, like for a certain period of time, like you cannot sue the criminal anymore. But this is possible. The case of Joseph S. and others is possible in German because German law does not have this statute of limitation for crime of murder and assisted murder, right? So I was wondering, like, why didn't German German law drafters include this statute of limitation in the law?
Well, that leads us to a very, very interesting issue. So indeed, as you say, currently the German Criminal Code does not have a statute of limitations for murder. But in the past, there was a statute of limitations. So in the old criminal code, so you need to understand Germany uses a criminal code of 1871. It's still the same criminal code with many changes along the way, but it is in its essence still that criminal code. In the initial version of that criminal code, the statute of limitation for murder was 20 years. And after the Second World War, the German authorities decided, or you can say, first of all, the occupant countries decided that the time of the Second World War itself would not count into the limitation. So at that time, still 20 years, And then it was decided that basically the statute of limitation is suspended until even the end of 1949, so that all actions committed during the Second World War, all acts of murder, could be prosecuted until 1969, until the end of 1969. So 20 years counted from 1949 because, that was then the starting point of the limitation. But then something happened, and that connects a bit to what we discussed earlier, that why were there so few prosecutions? There was a change of the law in the mid-1960s, And that is now a very tricky legal issue. But if you have 1 minute, I can explain it to you.
Yes, please.
All right. Yeah. So in this case, a law was changed that changed several parts of the criminal code and also introduced, for example, administrative offenses. But the main point of that law, in hindsight, which no one detected at the time when the law was made, was that it lowered the punishment for cases of assistance in which an assistant does not share the motives of the main perpetrator. Okay, now that sounds very technical. Now, let's assume a perpetrator commits murder out of very, you can say low motives. For example, because he has greed and wants to get the money of the victim. That can be a low reason, for example. I mean, a low motive. And now the law was changed, and the law then said, starting from, I think in the year 1965, when that was changed, the law said, an assistant who does not share these low motives, the punishment or the sentence of that assistant needs to be lowered. Because the argument was, well, if the assistant didn't really have this kind of bad intention, well, then the punishment for that assistant should not be as harsh as for the perpetrator. All right, so everyone thought, well, that sounds like a valid and reasonable law, and no one saw what that meant. Because what that meant was that all of a sudden, the punishment for assistance to murder in many cases was not 20 years anymore, but was only 15 years. Or was even less than that, So that then depended on how much you would lower the sentence, but that would affect also the statute of limitation, because as you know, the lower the punishment, the lower the sentence, the shorter the statute of limitation. And that meant that this law, enacted in, I think, 1965, retroactively cut down the statute of limitation for many persons, so that all of a sudden many perpetrators could not be prosecuted anymore, because by this law their act of assistance had already then passed the statute of limitation. And then afterwards, so this law was decided, and then afterwards many people ask, well, how could you not see that? Now we cannot prosecute many of these people anymore, because all of a sudden their acts are now not prosecutable anymore. And then people said, well, this was a bad mistake. We didn't see that. And I mean, if you just consider how many people are involved in drafting these laws, and this goes through many hands, this goes through the ministry, to many institutions, that no one saw this, that this will be one of the perhaps unintended consequences, is hard to believe. And actually, there is a name also that is often connected to this, which is the name Eduard Dreher. Eduard Dreher was one of a high-ranking civil servants in the Ministry of Justice in the 1960s, and it appears that he was aware that this was one of the consequences, but that he actually wanted that. There is quite some evidence for that. So now let's have a look at the overall picture. So initially 20 years of statute of limitations in the original criminal code. Then that was extended until, you'd say end of 1969. It was then actually later extended again to 30 years. Then that was 1979. And then actually in the year 1979, it was then changed to the current status where there is no statute of limitation at all for murder. But along this way, this other change in the law had occurred, which meant that many cases could not be prosecuted anymore. Now you may ask, why can then Joseph S. still be prosecuted? Why did that was not subject to this statute of limitation according to the shorter period because of this change in the law? Well, actually, the way out for the prosecutors is nowadays not to bring charges for murder based on low motives, because that would indeed then most likely mean that that is already then subject to the statute of limitations. But there is another opportunity. You can bring charges for murder for brutal commission of the act. And brutal commission of the act is not a low personal motive, but it is an objective mode of commission. So therefore, this law that cut down the statute of limitation time would not apply. And then these cases can then still be prosecuted until today, because for that, the statute of limitation has been changed, as you said, to, well, there is no statute of limitation anymore. Yeah, so that's basically what happened. By the way, I can also recommend you, if you're interested in that, the book, The Case Collini, written by Ferdinand von Schirach, which is also translated into Thai, that book. And that also speaks about this interesting case that perhaps there was someone in the German Ministry of Justice who wanted to help old Nazis and to make it impossible that they can be prosecuted.
Oh, okay. Yeah. So this was a very complicated thing, right? At first, there was a statute of limitation and then it was extended, and due to the wars and the change in law, several cases, now it is gone. And also we can see that prosecutors also try to use their chances to bring someone up to the court.
Right, exactly. So it's really quite sophisticated, but nonetheless, the current state is indeed that there is no statute of limitation for murder currently. And if you bring charges under a certain mode of commission for murder, then that is still possible.
Thank you for such an answer, Ajahn Lasse. But let's set the legal aspect aside for a moment. Like I said, you are a German of heart, of course. So as a German, what do you think about a century-old former Nazi guard being prosecuted? What is your opinion about this case?
Yeah, I think there are two ways to look at it. Yeah, so on the one hand, I would say the acts that were committed in German concentration camps were the most brutal and the most heinous crimes that had ever been committed on German soil. And even 70 years later, the victims demand justice. And I fully share this sense that justice needs to be done. On the other hand, you may say these perpetrators, these alleged perpetrators, have in the meantime lived a normal life. They have set up a family, they have children, grandchildren, and they basically have left this period of their life behind. They were in their early 20s mostly at the time when these acts were committed. And you may really think, do we need to punish these persons now? Now that, they have taken a different course in life, and you may ask yourself, should these issues really be brought up now? Now, I would say the issues can be brought up because of the severe nature of these crimes. At the same time, however, from the perspective also, from my personal perspective of a criminal defense lawyer, I would say it makes it quite difficult to defend these cases. On the other hand, you may also say it makes it equally difficult for the prosecutor to bring a valid case, because in several cases, so this is not the only case that is currently still in German courts, and there have been decisions also by courts that said, sorry, not enough evidence. We cannot hold the person liable. So we may even say the problem of evidence is something that both the prosecutor and the defense face.
Well, Ajahn Lasse, I would feel like the majority would agree with you. A great example would be this 100-year-old survivor of the Sachsenhausen camp, which, as Spike said, a place where Joseph worked as a Nazi guard. Such person who wished to bring justice for his friends and family. But it seems like not everybody shares the same idea, Ajahn Lasse. There are certain groups of people, like former concentration guard, and the majority of right-wing populist party, who said that the Holocaust is a subject that should be forgotten, and that it is time to move on. How would you respond to such claim, Ajahn Lasse?
Well, I would strongly disagree. I think, as I mentioned, the dimension of the acts that occurred during the Second World War in the concentration camps, so that about 6 million Jewish people have been killed in gas chambers and other ways of extermination. That is just a level of wrongfulness that and a level of brutality and cruelty that I think deserves until nowadays not only to be remembered, but where possible, also to be addressed by the criminal justice system. So we may say other crimes that are, you can say, general crimes under the criminal code, they should at some point be, you can say, people should move on, and peace in society can also be restored by just after a while saying, well, now everyone needs to move on. If we didn't bring that case within a certain period, then it's just too late. But I think for this kind of criminal actions, it is just a different dimension. And therefore, anyone who says it's time to move on, it's time to somehow leave this behind of us, you may need to understand that this is one of the defining moments of the German history in the 20th century. And it is also one that actually led Germany to become what it is today, to understand that violations of human rights are a serious matter and need to be addressed. And I think Germany has played, at least for the most part of the last 70 years, an active role in promoting human rights. And I think that would not have been possible without the lessons that Germany learned out of the Second World War. So therefore, my answer would be no, it's not the time to move on yet. It is still the time to keep the memory of this alive.
Okay, yes. So since, like, as you mentioned, we still have to prosecute them because we failed to do it at the first time. So I want to ask you, like, as a criminal defense lawyer, like, since this is not the first case in Germany, as you mentioned, there was the case of Oscar Gröning, who was like already dead before he was being tried. So since the law cannot prosecute a person who did wrongs while he was alive, do you think that maybe to a certain point, the justice system has failed to bring justice?
Well, Oscar Gröning actually did not pass away before he was found guilty. Yeah? So he was actually one of those cases where he was then, he passed away shortly after, but he was actually found guilty, and that was also confirmed by the Federal Court of Justice. But to answer your question, I very much think so, that this is a failure of the German justice system, that for many decades there was an inactivity of prosecution, and now doing that at this late stage is producing many problems, particularly of evidence, and also, I mean, if I were looking at this from the perspective of a defense lawyer, I would really mostly address the issue that assistance to some kind of a killing machinery seems to be a very, you may say, a very vague way of describing assistance. From a criminal doctrine or criminal law doctrine perspective, I would say assistance to a commission of a crime always needs to be the assistance to a rather concrete action. And now saying that someone who worked in a camp is thereby liable for assistance to murder, for example, in the case of Oscar Gröning, he worked as an office worker. He was not a guard. He worked as an office worker. He kept the documents and all of that. And he was then found liable for assistance to murder in 300,000 cases. Every case of a murder during the time when he was working in the concentration camp was then also attributed to him personally. And from the perspective of criminal defense and also criminal doctrine, I would say that is quite a problematic view that we generally in criminal law do not adopt. And it now seems that for these cases, because there is maybe a bit of a lack of evidence, it seems that now the courts have adopted this rather vague doctrine that allows this. So I would say the inactivity of prosecutors for many decades cannot justify now to make exceptions from criminal law doctrine, because criminal law doctrine does not only apply to these cases, but applies in all cases and needs to be consistent. And if we now start to make exceptions for these cases, because it is so difficult to find them guilty otherwise, then I think the collateral damage for criminal law doctrine can be quite strong. So therefore, I would really say the inactivity for many decades is a failure. And now one of the victims is also criminal law doctrine.
Well, thank you, Dr.Lasse, but I want to know, what do you think about the conflicts between ethics, morality, and justice? Like in the case like this, when defending a person who contributed to a genocide, how could just a lawyer face himself to defend such a person?
Well, I think generally criminal lawyers must be aware that they defend persons who allegedly have committed crimes. That is what you sign up to when you become a criminal defense lawyer. And your duty as a criminal defense lawyer is to hold up the criminal law principles and the procedural principles in order to have a fair trial. So even the worst criminal deserves a fair trial. Because in the end, it is the court that makes the decision and not the defense lawyer. So defending very brutal and heinous criminals is also part of what criminal defense lawyers do, because also for them a fair trial needs to be held. So therefore, I would say from an ethical or moral point of view, I do not see a problem from the perspective of criminal defense. Also, they deserve a full criminal defense.
Well, that was interesting in terms of criminal defense, right? Mr. Lasse, I would like to put you in a situation. You have mentioned that there are low evidence for the prosecutor to prove, to convict Mr. Joseph S. of being guilty, but it's also difficult because of low evidence to defend him as well, right? How would you, as a criminal defense lawyer, defend or prosecute this man with such a burden of proof and with low evidence due to the passage of time?
Well, if I were a prosecutor, I would very much rely on the Federal Court of Justice jurisprudence and say, the fact that we have documents that prove that Joseph S. was a guard in this concentration camp at the time when certain actions were committed, that is enough as a proof based on the existent jurisprudence. And I think that is what the prosecution currently does. I think the only evidence that they really have are these documents that show that Joseph S. was working as a guard at that time in the concentration camp. So as a prosecutor, it's even rather straightforward now because of this very beneficial jurisprudence that exists. As a defense lawyer, obviously, I would argue, well, the documents do not show much. The documents only show that he was there, but the documents do not show what he did. So I would very much then emphasize the fact that we need to have further proof of the actual duties that Mr. Joseph S. had. What was he? Where was he working in the camp? What were the exact duties that he had? So I think that is basically how the two sides would look at this case. And from the perspective of the defense, I would certainly also argue with the old age of the defendant and say that or raise the question whether it really makes sense to bring someone into prison who is now already 101 years old. Now, obviously, that would be the perspective of a defense lawyer. My personal perspective, I've said earlier already that I think, yes, even after 70 years, it may be justified because of the level of the crimes that were committed. But as a defense lawyer, I would certainly also argue with the age of the defendant.
Wow, okay. So the smoking gun that can be used to prosecute Mr. Joseph can also be used as a defense against him. That is interesting.
Well, yes, but I think in this case, the defense will have difficulty. So as we have seen in other cases like this, it is most likely that Joseph S. will be found guilty because, as I said, of the very beneficial jurisprudence by the highest courts in Germany.
Well, okay, Mr. Lasse, you have mentioned when Pi asked about the pragmatic and politically about the allies when they were prosecuting Nazis, right? How different is it for a criminal lawyer to defend a Nazi who was prosecuted by the allies? How would it be different from defending a Nazi who was being prosecuted by Germany instead?
Well, I think generally the criminal trials that occurred during the occupation of Germany that were then conducted by the occupying powers were living up to the procedural standards that you would also apply then in Germany. So therefore, I would say regarding these kind of trials, they were rather similar. Obviously, one was then conducted by the winners, so to speak, by the winning powers that were then also criticized as victors' justice, where then only Germans obviously were held liable, but none of the representatives of the French, English, or American troops were held liable for crimes that they have committed. So that could be something as a criminal defense lawyer that you could raise at such a case. It would not be very successful to say, well, you also committed crimes. It would not mean that the crimes that your defendant or your client has committed did not happen. I mean, these crimes happened as well. But that could be one difference, obviously. And we could see, for example, that in the Nuremberg main trial in the International Military Tribunal, the defense lawyers also tried to raise that and said, you are holding our clients accountable while representatives of your military have never been held accountable for any actions that they have committed, and that is injustice. So that could be what a criminal defense lawyer could raise. However, that is usually not that successful because, as I mentioned, that does not mean that the crimes that your client has committed did not happen.
Well, Mr. Lasse, you have mentioned in German law class, I was there for a while, in German law class, that the defense lawyer during the Nuremberg trials opted the defense of the fact that at the time of the commission, it was not a crime under the law of the Third Reich. How would this differ to Joseph S.'s case?
Right. Okay. So that is now a very interesting issue. Now, in the Nuremberg trial, the defense lawyers also said that. Yeah. So they said there were laws in place at the time in Germany that actually legalized these actions. So the running of concentration camps, for example, was basically part of what the German legal system at the time during the Nazi regime allowed. Now, in the Nuremberg trial, that could be disregarded rather easily because that was an international trial under international law. And that meant that any domestic legalization would not have any effect on the international legal framework. Here, however, with Joseph S., we are in a different situation where the law that is applied is German criminal law. And as I mentioned, the criminal code that is in force now is the same that was in force during the Second World War, because it is the criminal code of 1871. So now we are really in a situation where we need to ask, are now these actions in the concentration camps, are they subject to any exemption because of a legalization in other laws? Now, with regard to that, I would like to raise a case that the Federal Court of Justice has decided in a different scenario, related not to the Nazi regime, but related to the German Democratic Republic, which was Eastern Germany, the socialist Eastern Germany, which, as you might remember, built the Berlin Wall in Berlin to separate West and East Berlin. At the Berlin Wall, many people have been killed. About more than 100 people have been killed who tried to flee from the East to the West. After the German reunification, the German Federal Court of Justice was faced with cases where border police were charged with murder for shooting at persons who wanted to leave Eastern Germany. And they were held liable, criminally liable. But in this case, in these cases, these border policemen of Eastern Germany, they could actually say that the border protection code at the time in force in Eastern Germany justified these actions or allowed these actions, authorized also the use of lethal force. And they said what we did was in accordance with the law. But in that case, the Federal Court of Justice of Germany said, you should have been known that any law that justifies the killing of innocent people cannot be valid law. So the court really disregarded this fact and said, these border protection codes that existed at the time, you should have known that they could not be a legal basis to justify these actions. And I think that is basically the reasoning that is then applied also to other cases, also to the Joseph S. case, where the court will most likely respond to this claim saying, well, you should have known that any legal basis that tries to legalize the killing of innocent people in a concentration camp, any such law could not be valid because it is a violation of the most basic principles of justice, and you should have been aware of that.
Well, it is an interesting thing. So I would like to put you into a final role. If you were a judge in this case, how would you actually decide the outcome of this case to be? Yes, referring to Mr. Joseph S. case.
Right. I mean, as a judge, I have to apply the law. And the law is currently interpreted by the Federal Court of Justice in a way that would very much justify holding Joseph S. accountable. It is very difficult for the court in Neuruppin to depart from the now quite established Federal Court of Justice jurisprudence. Now, as you know, Germany is not a common law country, so the lower courts do not have to follow the federal court. They could still decide differently, but in fact, judges tend to do that and to follow the highest court. So therefore, If I were a judge and if I need to apply the law and not my own personal opinion, but the law, obviously, then I think I would hold Mr. Joseph as liable, criminally liable. But the punishment, I think, needs to reflect also the time that has passed in between and also the high age of the defendant. So, for example, in the case of Oskar Gröning, he was found liable for assistance to murder in 300,000 cases and was held criminally liable and was sentenced for 4 years imprisonment. I think in this case, with assistance to murder in about 3,500 cases, we might expect a punishment of about maybe 2 years imprisonment.
Wow, okay. That was great. Thank you.
Okay, so yes, that was a very, very interesting and eye-opening discussion. We get to see how like the law and judicial system evolves. Like, it can be heavily influenced by both politics, significant events such as the World War II, and also by jurisprudence. I also find it like very fascinating, and I believe others feel too, to get to know how law practitioners form their arguments or like take advantages of the law to prosecute or even defend someone. So we would like to thank you so much, Dr.Lasse, for your insights, knowledge, and also your time.
Thank you very much for inviting me. It was really my pleasure to share some of the interesting issues about this case.
Well, Dr.Lasse, would you like to leave any closing thoughts for our viewer?
Well, my closing thought would first of all be to always stay interested in this podcast and to continue following that. And in that spirit, I would say, ฝากติดตาม I Rest My Case podcast ด้วยนะครับ
Thank you.
Thank you for promoting our show. Thank you, Dr.Lasse, again for his time and knowledge.
Yes, and I also want to thank you, every audience, every one of you, for listening to this episode up to this point. We hope you find this enlightening and insightful. Now the time for this episode is over, so please don't forget to follow us, LL.B Radio, on Instagram and Facebook. And for more episodes, please keep an eye out for us on Spotify and YouTube.
Well, this has been I Rest My Case. Please stay tuned for more episodes. We'll see you soon.
Thank you. Bye-bye.